So I'm going to be talking about the future of jurisprudence. And I have to tell you that this presentation is a distillation of what I have learned myself over the past 2 days. I want to pay homage to all the presenters who have presented. I've learned a lot. And in particular, I want to pay tribute to Dr. Wendy Hollingsworth, who helped me put together this presentation this morning. I think one of the basic building blocks of our future jurisprudence has to do with the factual matrix that we are confronted with in the region. And essentially, we want to make the point here that there are already facts on the ground which will support the emergence of cases and therefore of jurisprudence in the future. So we have a situation where there are geographical indications protecting products in several of our CARIFORUM and CARICOM member states. The Dominican Republic started off, of course, with coffee. In Cuba, cigars are protected by GIs. In Jamaica, jerk seasoning. Guyana, Demerara rum. And in Trinidad and Tobago, there's cocoa that is protected by geographical indications. We also learned, of course, that there are products which are protected by the sister IP regime, if you will, of trademarks. In Jamaica, the Blue Mountain Coffee, Dominican Republic, the Oreo de Val. These are protected by trademarks, but they could also perhaps benefit from protection by geographical indications. There's, of course, the Jamaica-made mark, which is not so much related to GIs, but indicates a more or less voluntary scheme of certification goods in Jamaica having achieved standards set by the Jamaica Bureau of Standards. An important area that we didn't really go a great deal into is the area of services. And I did hear something from, I think, Virginia this morning earlier about services in Europe. But the point is that this is in general an emerging area where services can be protected by geographical indications. And this is an area perhaps that the Caribbean ought to get involved in, because after all, we are not as well positioned to be famous in the production of goods as, say, the US or China or India. Our niche is really in the production of services. And obviously the extent to which our services can be protected by GIs, they are already protected by trademarks. That would in fact be a good thing. Some of the areas where this could be relevant is in the music field, for example, not so much as we heard, I think, yesterday from Lily Claire and also from Erica, the genre of, say, reggae, but perhaps the production services which go into the making of the music, perhaps that could be protected. There's an article by Hollingsworth and Smith, 2017, exploring this issue. And in the clothing industry, Seville, Rowe, Bespoke, and Harris Tweed, dealing with tailoring services, illustrate that there is right now a discussion about moving the protection offered by GIs beyond the agricultural industry and into the services industry. And the point that is made, and I echo what Dr. Hollingsworth has said here, we really need to be part of the dialogue which extends the range of protection offered by GIs beyond the traditional production of agricultural products. The legal regime that is needed to support or respond to what is happening on the ground, there are, of course, treaties, legislation, and so on. In relation to treaties, I think the region is fairly well represented in treaties dealing with intellectual property rights generally. Not so much, however, in relation to the two areas that we have spoken about over the past 2 days. In relation to trademarks, for example, only 2 of our countries are parties to the Madrid Protocol, Antigua and Barbuda and Trinidad and Tobago. And in relation to geographical indications, the Geneva Act has not yet been accepted, as far as we're aware, by any of our member states. Contrast that with the position in legislation, because a majority of CARICOM states have tailor-made or sui generis legislation on both GIs and TM. So there's some degree of disconnect between the treaty acceptance and the implementation of legislation. And that was, I think, explored somewhat yesterday. There is being negotiated an intra-CARIFORUM GI agreement, which would allow for GIs protected in one member state to be protected throughout the range of CARIFORUM member states. And of course, we know that there are currently negotiations going on between the EU and CARIFORUM in relation to the mutual protection of GIs. Adjudication by national courts. Now, national courts here, of course, includes our courts of record, the Supreme Court, the Court of Appeal, and then the highest court, the Privy Council for many countries, Judicial Committee of the Privy Council, and in relation to the CCJ, the appellate jurisdiction for those countries which have accepted the AJ of the CCJ. There's, generally speaking, a dearth of case law in the Caribbean, dearth of jurisprudence on this. I think Mrs. Washington Bialba did an exemplary job earlier in pointing to some of the cases which do exist. But generally speaking, there's not a lot of cases in this area. Why? One is not absolutely sure. It may be that the registrars of the intellectual property offices managed to ameliorate, to divert some of the conflicts which may arise in relation to registering conflicting trademarks, for example. It may be that some of the issues are resolved through the criminal process, and some of these criminal courts are not courts of record, and therefore they will not be records of the cases decided in that process. And it may be that there's not enough emphasis being placed on research. As I mentioned, there is a little research that has been done so far, and it has in fact harvested a number of cases. And there is in train a project between the Academy and WIPO to do a comprehensive review of all the cases in the region touching upon IP generally, and in particular on the areas that we have been concerned with over the past 2 days. There's also the possibility, moving away from national courts, of a referral to the CCJ. There is a provision in the revised Treaty of Chaguaramas, Article 214, which allows national courts to refer matters touching on concerning the revised treaty to the CCJ for an authoritative interpretation. And that interpretation is very important because it allows for the harmonization of concepts throughout the region. So a court in Barbados, a court in Jamaica, in Trinidad, in Guyana, Belize, they may have different interpretations of the very same concept of misuse, for example, or imitation. But if the matter is referred to the CCJ and the CCJ gives a definitive opinion, then of course it harmonizes the interpretation of those concepts throughout the region. Already referrals are being used by the European Court of Justice, as we heard yesterday, and as we heard today, Rebecca and Virginia. It's being used as well by the Court of Justice of the Andean Community, as our previous speaker would have mentioned. And in the Caribbean Court of Justice, there is the possibility of referrals based, for example, on Article 66 of the RTC, which deals with IP rights. There is the possibility as well of referrals coming through based on interpretation of the provision dealing with provisions dealing with services, and also the provisions on trade in goods. I raised what I hope is a provocative question of whether there could eventually be referrals from non-CARICOM but CARIFORUM countries so as to harmonize interpretations throughout not just CARICOM, but also beyond and within the CARIFORUM industry. And do we also need a database of IP and related experts who will assist the court, not just the CCJ in referral matters, but also national courts in resolving IP issues. And finally, I think the future of jurisprudence is also dependent heavily on the enhancing of our legal competence. It seems to me that training and capacity building is required. Very good efforts are being undertaken in regional legal education at the moment. In UWI, postgraduate and undergraduate studies are looking at IP issues. We are very grateful for the developmental assistance we get from various fora like this one. And then finally, we are of course cognizant that there is a linkage between the development of this jurisprudence and trade development and innovation. I think I saw your face 55 seconds ago, Chair. Thank you very much.